So they decide to have these hearings. Senate panel sets up hearings on impeachments of rogue judges. And of course, a star participant would be Judge James Jeb Boasberg, would he not? Arguably, one of the most corrupt, most insurrectionist judges we have serving on the federal bench. And what does he say? He says he's not showing up. No, I'm not showing up to this hearing. Now, when Trump administration officials in his first term were subpoenaed by the Democrat Senate and didn't show up, they were criminally prosecuted and put in a federal penitentiary. You think that's going to happen to Boasberg? You think it should happen to Boasberg? He said, well, Boasberg's not going to appear because that would encroach upon the separation of powers and the independence of the judiciary for judges to be required to explain their deliberative processes in reaching judicial decisions. So they can issue these orders and they don't have to explain them to anybody. How is that different than tyranny? Exactly. Does Trump get to say the same thing back to the federal judiciary? We don't have to explain to you why we're doing what we're doing. We're just going to do it. Wouldn't that make the Article 2 executive branch a bit more administratively efficient than it is currently, with these federal judges like hyenas constantly biting into the flanks of our democratically elected Article 2 executive branch, President Donald J. Trump, and our commander-in-chief? Some new headlines with Boasberg. Obama appointee, of course, chief judge of the District of Columbia Circuit, which in my opinion doesn't even need to exist. The United States went many, many, many decades without having a federal district that was the District of Columbia. It used to be we only had district courts for the states. If there was an issue in the District of Columbia that needed addressing in a federal district court, it would be farmed out to one of the non-DC districts, more or less randomly assigned to some judge somewhere in the country. There were no District of Columbia federal judges. That's a system I think we should go back to because I think the District of Columbia inherently politically corrupts everything. A third of the 15 federal judges in the District of Columbia, they're foreign born. They're not natural born Americans. They're born in Trinidad. They're born in Uruguay. They're born in foreign nations. They're born in Ukraine, but not America. And now they have a lifetime appointment on the federal bench. Some of them even still maintain dual citizenship. Why do we want? How is it in America's interest to have foreign-born judges? You think many other nations allow their most senior level of judges, their equivalent of federal judges with lifetime appointments? You think they allow them to be foreigners, paperwork citizens? Of course, there's been a lot of trouble with rogue judges. And the GOP Senate said, hey, let's have some hearings on this. Let's have some hearings on the impeachment of rogue judges. Now, of course, as I've mentioned, you need 67 votes in the Senate to impeach. We don't have 67 votes, so we can't pretend that we're going to actually be able to impeach and remove any of these judges. But I think the hearings would be useful, calling these judges in, compelling them to testify under oath in front of Congress, in this case, in front of the Senate. I think it would be helpful to put these judges in the spotlight. Now, if we can't impeach, I'm still of the position that we can fire. Fire and impeachment are two different things. Impeachment is being convicted by the Senate of high crimes and misdemeanors. In a civilian setting, that would be like you being convicted of a felony. Before you can be convicted of a felony, there's a lot of due process protections, right? You're entitled to a trial, a jury of your peers, representation. If you can't afford your own lawyer, we'll assign one to you. There's rules of evidence. There's all kinds of due process you get before you can be convicted of a felony. But you don't get any of that if you're just going to be fired from your job, right? Those are two different things. So in the Constitution, it says you can impeach officers of the U.S., and we treat federal judges as officers for impeachment purposes. We have impeached and removed convicted federal judges before. But there's another provision in Article 3 that says judges serve during good behavior. We're all told that federal judges have a lifetime appointment. But that's not actually what Article 3 says. Article 3 does not say that federal judges have a lifetime appointment. Every other branch of government, Article 1 legislative branch, has explicit temporal limits on service. So congressmen have to run for re-election every 2 years. Senators have to run for re-election every 6 years. In the Article 2 executive branch, it's 4 years. It's spelled out. It's an explicit time limit. President has to run for re-election every 4 years. But in Article 3, there is no temporal time limit to service. What we say is, what Article 3 says is, judges serve during good behavior. And that's been interpreted to mean a lifetime appointment. But what if they're serving during bad behavior? Maybe not enough to qualify for conviction of high crimes and misdemeanors, the equivalent of a felony, but maybe enough to warrant termination. Hey, we're not saying you're a felon. We're not saying you committed a high crime or misdemeanor. We're just saying you're not serving during good behavior. You're not serving as a judge properly ought to. And there are rules for this. What qualifies as good behavior created by the Article 3 judicial branch itself, not imposed on them by Congress or by the president. The Article 3 judicial branch has a code of judicial conduct. And if you violate those codes, clearly that would be adequate to argue that they're not serving during good behavior and should be fired. And a lot of these judges are not. They have conflicts of interest. They're not being impartial. They're not being unbiased. I mean, it's patently the case. So how would you fire them? Well, how were they hired? How were they hired in the first place? All it takes to hire a federal judge is a majority vote. Why can't you just fire them with a majority vote? So they decide to have these hearings. Senate panel sets up hearings on impeachments of rogue judges. And of course, a star participant would be Judge James Jeb Boasberg, would he not? Arguably, one of the most corrupt, most insurrectionist judges we have serving on the federal bench. And what does he say? He says he's not showing up. No, I'm not showing up to this hearing. Now, when Trump administration officials in his first term were subpoenaed by the Democrat Senate and didn't show up, they were criminally prosecuted and put in a federal penitentiary. You think that's going to happen to Boasberg? You think it should happen to Boasberg? He just decided he's not going to show up. He also mentions, hey, one of the big things that's on fire right now is he signed a bunch of search warrants for spying on GOP senators, and then he signed non-disclosure orders. Because by law, senators are supposed to be notified if the FBI is spying on them. But Judge Boasberg said, no, I'm going to sign these non-disclosures. And now he says, when I signed the non-disclosures, I didn't know what they were for. I didn't know the warrants that were not being disclosed were for searches of U.S. senators. Anybody believe that? So he was just giving subpoenas without knowing who was being subpoenaed, approving subpoenas. These are actually warrants. If that's true, that alone requires impeachment. That's just judicial incompetence. And when he refused to go, he had the administrative officers of the United States courts send in his note declining to appear before the Senate. And they wrote on Boasberg's behalf, your letter inquiring about Chief Judge James Boasberg's decision-making during the issuance of these non-disclosure orders for the spying on the senators has been referred by Boasberg to me, Honorable Robert J. Conrad, Director of the Administrative Offices of the United States. So Boasberg's not replying himself. He's having a puppet do it for him. He said, well, Boasberg's not going to appear because that would encroach upon the separation of powers and the independence of the judiciary for judges to be required to explain their deliberative processes in reaching judicial decisions. So they can issue these orders and they don't have to explain them to anybody. How is that different than tyranny? Exactly. Does Trump get to say the same thing back to the federal judiciary? We don't have to explain to you why we're doing what we're doing. We're just going to do it. Wouldn't that make the Article 2 executive branch a bit more administratively efficient than it is currently, with these federal judges like hyenas constantly biting into the flanks of our democratically elected Article 2 executive branch, President Donald J. Trump, and our commander-in-chief? All right, so I've done this before. I'm doing it again. My buddy Bill, Shipwrecked Crew, former federal prosecutor, also did a lot of federal defense work he was the defense attorney for almost 100 of the January 6 protesters. And very smart lawyer. He and I have talked quite a bit, and he writes these columns on his Substack. And from time to time, I'll share those with you because he does a great job of distilling a lot of these issues and arguments, and it saves me some time. And he's given me permission. Blank check to share his stuff. Now, in exchange, I do urge all of you to check out his Substack. There's a link to that in the description, so you can become a member. You have to pay to be a member. He often puts stuff up like that's open access for 7 days. I think that's true of this article too. But generally, he'd like to be paid for his work, which is appropriate. And I also put a link to him on X, so you should follow him on X too. It's just at Shipwrecked Crew. All right, so the title, Boasberg v. Trump administration, what is next in the Alien Enemies Act case? The next few days, Bill writes, may produce some fireworks on the Alien Enemies Act case that's once again heating up in the courtroom of D.C. District Court Judge James Boasberg, goes by Jeb. 2 weeks ago, the D.C. Circuit returned the case to Judge Boasberg. It authorized him to start over in considering a possible criminal contempt proceeding against unidentified members of the Trump administration for supposedly defying what he claims was a clear and direct order. The supposed order was that the Trump administration not turn over to the government of El Salvador individuals who were removed from the U.S. on March 15th, pursuant to President Trump's invocation of the Alien Enemies Act, designating members of Tren de Aragua, violent gang based on Venezuela, as subject to the Alien Enemies Act. By the way, Boasberg was on vacation when this happened. And at any time in any federal district, there's always a judge, an emergency judge, on a rotating basis assigned to fast-breaking cases. Something happens in the middle of the night, they need a federal judge, that judge is on call. When this Alien Enemies Act case broke, when these Tren de Aragua guys were being flown out of the country and suddenly had a bunch of lawyers, it didn't go to the emergency judge in the D.C. Circuit. Judge James Boasberg, on vacation, somehow, magically, at 1 a.m. in the morning, happened to be in his office when this case was filed. And he grabbed it. Does anybody think that's a coincidence? Does anybody think that wasn't coordinated? That Judge James Boasberg made damn sure that he was the judge who caught this case? He's like the Forrest Gump of obstructionist federal judges. Again, he was involved in the FISA warrants, the January 6th prosecutions, the slap on the wrist case against FBI provocateur Ray Epps. He was involved in the non-disclosure of the spying warrants on the Senate. This guy's everywhere. He was the judge at that judicial conference that, oh, what are we going to do if Trump doesn't obey an order? He's everywhere. And everywhere he is, he turns our Constitution to shit. Back to Bill's piece. The Supreme Court later ruled that Judge Boasberg lacked jurisdiction to enter the order because there was no venue for a habeas proceeding. So that's how this case was brought into D.C. to Judge Boasberg's court. These Tren de Aragua terrorists demanded a habeas hearing. A habeas hearing means you're brought into federal court and the government has to explain why they've detained you, why you're under arrest. It's one of the core due process rights we have in America. So we can't have a secret detentions. You have a right to have the government explain to a federal judge why you're being detained. And by the way, the Alien Enemies Act itself, in its text, has very limited due process. But the one bit of due process it has is you do have a right to be brought before a federal judge and have the government explain the basis for applying the Alien Enemies Act to you. And the reason that's included is it seems fair to make sure before we deport someone as an alien enemy that they qualify as an alien enemy. For example, you wouldn't want, Joe, the local plumber, who maybe has a passing resemblance to a Tren de Aragua terrorist, to accidentally be grabbed, deported, an American citizen actually, accidentally be grabbed, deported to the tropical prison resort in El Salvador of Sicat. Right? You'd want him to have an opportunity to say in front of a federal judge, they just got the wrong guy, Your Honor. I'd never even been to Venezuela. So that exists in the Alien Enemies Act as due process. Now, of course, that does not help you if you're actually a member of Tren de Aragua. And what's the burden of proof on the government? It's basically a more than zero evidence burden. They have reason to believe that you fall within the definition. You're not Joe the plumber. You got the face tattoos. They have surveillance. They have confidential informants. They have evidence that you're Tren de Aragua. Off you go. Off you go. The trouble here was if you're bringing a habeas claim in federal court, again, what you're fundamentally asking is, I want the government to justify why they're holding me. Well, the federal court you need to be brought to is the federal court in the district where you are being held. These Tren de Aragua guys were being held in Texas, in a detention facility in Texas. Yet they filed their habeas appeal in the District of Columbia. Why do you think they did that? Well, we know why, right? We know why, because they knew that if they filed in the District of Columbia, they weren't going to end up with some conservative Texas federal judge. They knew, their lawyers knew, Judge Boasberg was going to be in his office at 1 a.m. to catch that case and give him favorable rulings. But that's not how habeas works. So Boasberg knows this. Every federal judge knows this, that they were supposed to file in Texas and not in the District of Columbia, but he just waved it away. And he issued his orders anyway. And then Trump had to fight it all the way to the Supreme Court before the adults in the room said, Boasberg, you have no power here. You don't have jurisdiction. The Supreme Court also ruled, back to Bill, that individuals to be deported under the Alien Enemies Act had certain due process rights to contest whether they were actually covered by the Alien Enemies Act proclamation before being deported. And as I said, that's right in the text of the Alien Enemies Act. That's about the only due process you get under the Alien Enemies Act to challenge the government to present their argument why you fall within the scope of the Alien Enemies Act proclamation. Back to Bill. Late in the afternoon on Saturday, March 15th, 2 planes left a Texas airport. They were in Texas, with approximately 200 Venezuelan nationals on board, headed for the tropical prison resort of Secot in El Salvador, where they would be detained by the Salvadoran government until Venezuela agreed to accept their repatriation, because Venezuelan didn't want their terrorists back. Venezuelan sent the terrorists here. These are agents of the narco-terrorist government of Venezuela. Venezuela sent them here to cause trouble. That's why Trump proclaimed the Alien Enemies Act. So Venezuela doesn't want them back. They're invading troops, in effect. Around the same time that day, Judge Boasberg held a hearing, at the end of which he granted the plaintiff's motion for a temporary restraining order blocking their removal. The TRO said, you can't remove any more of these people from the U.S. During the hearing, he didn't have jurisdiction for that either. During the hearing, he gave an oral directive to the Department of Justice attorney that any planes in the air should be turned around and the passengers brought back. He followed up with a written order approximately 40 minutes later that was not as specific. It didn't mention turning around the flights in the air. And here's the whole problem, folks. It's like if you've ever been in any lengthy meeting, argumentative meeting, which is what a hearing is in court, right? It's an adversarial, argumentative hearing. People are making arguments. They're asking for things. They're asking that things not be done or not be ordered. The judge is listening. Questions are being asked. Arguments are being formed. Decisions are being made. But it's very amorphous, right? In the hearing itself, it's fluid. It's fluid. And then at the end of a court hearing, how it works, after hearing all the arguments, all the evidence, all the issues, the judge says, all right, I'm going to distill all of this down in written form as a final order. And it's written so there's no risk of ambiguity or uncertainty, so everyone knows precisely what's covered and what's not covered. And then he sends the written order out to the parties, and they have to follow that written order. But it's not hard to imagine, in a lengthy hearing, argument, discussion, debate, that things might be said in the course of that ultimately are decided against. You might say something in the middle of a meeting and said, hey, we should do X. But then after further argument and discussion, everyone realizes, X doesn't make sense. And therefore, X is not included in the final decision, in the final written order. And that's what happened here. This judge says, I want the planes turned around in international airspace. And then he does not include that condition, that instruction, in the final written order. So is that passing oral remark? Is that supposed to be grounds for criminal contempt when the final written order issued 40 minutes later, a mere 40 minutes later, did not include that verbal order? By the way, as we'll see, the verbal order itself, the oral order itself, was very wishy-washy and ambiguous. Bill has quotes here from the transcript. By the way, the White House, the administration, did not have the transcripts here. Would you believe, not only do we have this dynamic where it was an oral statement by the judge that was not included in his final written order, the judge literally told the parties during the hearing, they were taking notes. They were taking notes. And you know what the judge told them? Don't take notes. Don't write anything down. You don't have to worry about what we're saying here right now, because I'm going to reduce everything to a written order. And then he wants to hold the Article 2 executive branch in criminal contempt for failing to abide by the stuff he told them not to take notes on. And by the way, for which there was no transcript available in the moment. Transcripts come later. This guy is an utter shitbag. You think this was not deliberate? You think the judge who was in his office miraculously on vacation, but in his office at 1 a.m. to catch this case, the judge who weeks earlier at a judicial conference said, hey, let's be on the lookout for Trump disobeying orders. You think he didn't set this as a trap deliberately? I'm going to say something in passing. I'm going to prohibit the parties in front of me from taking notes on what I'm saying. I'm going to tell them, don't worry about it. I'll issue a final order. I will not include in the final order precisely the instruction that I'm later going to attempt to hold them in criminal contempt. Anybody think this is being done in good faith? Yes, I have feelings about this judge. So Boasberg followed up with a written order approximately 40 minutes later that was not as specific. It did not mention turning around the flights in the air. The flights landed. The deportees were off the planes. They were turned over to Salvadoran authorities and sent to Sican, the tropical prison resort for terrorists. There were additional hearings where the sequence of events was a matter of controversy, leading to Judge Boasberg finding there was probable cause that one or more Trump administration officials could be found in criminal contempt for willfully disregarding his verbal order on March 15th to turn the planes around. The Department of Justice appealed, and the D.C. Circuit Court of Appeals vacated his probable cause finding, but it authorized him to revisit the question in a new proceeding by starting the process over again. So this is a little inside baseball, but the reason this happened is Boasberg had essentially attempted to extort the Article 2 executive branch. Boasberg had said, I'm going to hold you in contempt unless you fly them back. So he's attempting to compel the Article 2 executive branch to do a particular thing. He doesn't have the authority to do that, making his contempt conditional on them doing something. You can find somebody in contempt, but you can't make the threat of contempt be a club to compel their behavior. So that's why he was reversed. But they sent it back to him and they said, but listen, if you have independent grounds of contempt, just find him in contempt if you can. You just can't use it as a club. So that's what he started doing. The plaintiffs, all in Venezuela, are continuing their efforts to obtain injunctive relief against their removal. I mean, they've already been removed. They're seeking an order from Judge Boasberg that the Trump administration work with the Venezuelan government to facilitate their return to the United States. This language is from more obstructionist judges. So we had one of these obstructionist judges, a woman, ordering Trump to bring back terrorists. And it went all the way to the Supreme Court, and the Supreme Court said, no, you can't order Trump to do that. You can order Trump to facilitate their release from the prison, but it didn't say to facilitate their return. And then they remanded the case back to the judge, and what was the judge's next order? Well, you have to facilitate their return to the U.S. That's not what the Supreme Court said. This is not complicated English terminology. That trial judge, an unelected black robe, tyrannical inferior district trial court judge, she knew damn well that all the Supreme Court had allowed for was their release from prison, not their return to the U.S., but she pretended she misread it. So that put into our arguments on all these cases this notion of facilitate their return. The Supreme Court never ordered the facilitation of anybody's return. They're just pretending that happened. It's contemptible. If they were returned, that would allow them to assert their due process right to contest whether they were ever subject under the Alien Enemies Act and to seek asylum or withholding of removal to Venezuela under immigration law. Even though the Supreme Court held that Judge Boasberg lacked jurisdiction to enter his order on March 15th, for reasons we discussed, it is well established and settled law that such orders are binding until reversed by a higher court. The fact that he lacked jurisdiction is not a basis to allow the parties to ignore the order before it was overturned. Again, this is a general rule. Bill is right here. This is the rule. It's a rule that works well when you have judges who are acting in good faith. It's not a rule that works well when you have judges acting in a knowingly lawless manner. So you can imagine a trial judge issues an order, and later on, for some technical reason, a court of appeal says, well, that order wasn't really lawful. But in the meantime, if it had a facial appearance of arguably being lawful, you would want the parties to follow it until the higher court has ruled it unlawful. But that's different than when you have a judge issuing orders that are patently patently unlawful, patently without jurisdiction. Judge Boasberg had been informed by the Trump administration when he issued these orders. We don't even think you have jurisdiction, Judge. This should be happening in Texas. And he issued the order anyway. It was never going to be lawful. That's a rather different matter. But technically, when the order issues, you're supposed to follow it until it's been overturned by a higher court. But here's the thing. Was there an order issued? By that, I mean, should the White House have understood that the instruction to turn the planes around was effectively in order? When it was said in passing, in a wishy-washy way, and followed 40 minutes later by a final written order that said nothing of the sort, a final written order that the Trump administration followed to the letter, and it said nothing about turning the planes around, should the White House have understood every passing remark in the hearing by the judge, every passing remark the judge prohibited them from taking notes on, should be treated as much as an order in this case as the final written order the judge delivered to them? That's the question. Was the instruction to turn the flights around, was it effectively in order? Should the White House have understood that to be in order? Or, given the presumption of regularity and the presumption of good faith of the other branches of government, should a judge have said, given the ambiguity here, I can see there's a reasonable party, Article 2 executive branch party, may not have understood that to be part of the final order. That's not what this judge is doing, though. This judge is bending over backwards to attempt to find fault with this administration because he's not impartial and he's not unbiased. He's a political activist for the progressive fascist left.